Most Americans can name the First Amendment as protecting free speech, but fewer than 1 in 4 can actually recite what it says. Today, we'll read the actual text and examine what each clause means and what it doesn't protect. The First Amendment to the United States Constitution, ratified in 1791, reads, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances." This single sentence protects 5 distinct freedoms through 2 religious clauses and 3 expression clauses. The Establishment Clause, respecting an establishment of religion, prevents the government from establishing an official religion or favoring one faith over others. This doesn't mean removing all religious references from public life, but rather ensuring government neutrality in religious matters. The Free Exercise Clause, prohibiting the free exercise thereof, protects individuals' right to practice their religion freely. However, this protection isn't absolute when religious practices conflict with secular laws. Freedom of speech, abridging the freedom of speech, protects expression from government censorship. This includes not just spoken words but also symbolic speech, written expression, and even some conduct that communicates ideas. Freedom of the press, or of the press, ensures journalists can report news and publish opinions without prior government restraint. This protection has proven crucial for government accountability and democratic oversight. Right to assembly and petition, the right of the people peaceably to assemble, and to petition the government for a redress of grievances, protects peaceful gatherings and the right to ask government for policy changes through protests, petitions, and advocacy. The First Amendment only restricts government action, not private companies, employers, or social media platforms. When Twitter bans an account or a company fires someone for their statements, that's not a First Amendment violation. The amendment also doesn't protect all speech. From the beginning, courts have recognized that certain categories receive limited or no protection: obscenity, defamation, fighting words, true threats, and speech that incites imminent lawless action. Another misconception involves religious freedom. The amendment doesn't grant unlimited religious exemptions from secular laws, nor does it require complete removal of religious symbols from public spaces. Gitlow versus New York in 1925 fundamentally expanded the First Amendment's reach. Benjamin Gitlow, a socialist, was convicted under New York's criminal anarchy law for publishing materials advocating government overthrow. While the court upheld his conviction, it established that First Amendment protections apply to state governments through the 14th Amendment's Due Process Clause, not just federal restrictions. Schenck versus United States in 1919 established the clear and present danger test during World War I. Charles Schenck distributed leaflets urging resistance to the military draft. Justice Oliver Wendell Holmes wrote that speech could be restricted when it creates a clear and present danger of bringing about illegal acts. Though this test was later replaced, it marked an early attempt to balance free speech with public safety. Abrams versus United States in 1919 saw Holmes articulate his famous marketplace of ideas philosophy in dissent. Russian immigrants were convicted for distributing leaflets criticizing U.S. intervention in Russia. Holmes argued that the best test of truth is the power of the thought to get itself accepted in the competition of the market, laying groundwork for more protective speech doctrine. These early cases reveal that First Amendment protections were initially quite limited. For over a century, courts generally deferred to legislative restrictions on speech, especially during wartime or periods of political tension. James Madison, who drafted the amendment, drew inspiration from Virginia's Declaration of Rights and Enlightenment philosophers like John Stuart Mill. The amendment emerged from colonists' direct experience with British censorship, religious persecution, and restrictions on assembly and press. The founders intended these protections to prevent the new American government from repeating the oppressive practices they had experienced under British rule. However, translating these broad principles into specific legal protections would require decades of constitutional interpretation. Understanding what the First Amendment actually says remains crucial in our digital age. Contemporary debates about social media censorship, religious liberty, and protest rights all require clear understanding of what the amendment protects and what it doesn't. The amendment's text has remained unchanged since 1791, but its interpretation continues evolving as courts apply these principles to new technologies and social circumstances. The First Amendment's 5 freedoms form the foundation of American liberty, but their practical application has been shaped by over 2 centuries of legal interpretation. Next time, we'll examine how landmark Supreme Court cases transformed these protections into the robust shields for expression we recognize today. What Supreme Court case would you like us to cover next? Let us know in the comments, and subscribe for more constitutional law content.